Hi, this is Judge Herb Dodell. I want to talk to you today about small claims court. We've talked about it many times in the past, both on YouTube's and on the radio show, which you can listen to, by the way, by going to judgeherbdodell.us, click on radio shows, look for the index, and pick a subject that is interesting to you. I've talked a lot about small claims court because I've presided over thousands of small claims court cases. I'm still doing it, as a matter of fact. The reality is that it's a great venue to get your issues resolved inexpensively and quickly. So here's an illustration. A party came in and asked me whether or not they could sue their former landlord because there had been a fire and they weren't able to use their property fully. It's called an abatement. A-B-A-T-E-M-E-N-T, abatement, meaning a reduction because of the inability to use it. It had to do with air conditioning and heating. But the total damages were only $15,000. When I say only, I'm just talking about it in terms of comparing it to large cases that clearly don't belong in small claims court. And ultimately, the cost of litigating a $15,000 case in the regular, what's called limited jurisdiction court, is prohibitive. You have to hire a lawyer. And the lawyer is going to file a complaint, and then there's going to be an answer, and then there's going to be a deposition. Not practical. So I advised these clients, I said, you know what, go to small claims court. You're going to be limited to $10,000, but wouldn't you rather have $10,000 net as opposed to spending money on lawyers and not knowing what you needed to do? All you need to do is be prepared on the subject of abatement. Go to Google, look it up, go to court, have your authority with you, and the chances are you'll get your $10,000 if it's justified. And it may very well be that once the defendant has been served means advised of the lawsuit and requiring them to respond, they may recognize settlement is the way to go to avoid the risk. Remember, I'll just give you a couple of basic facts about small claims court. Number one, a plaintiff does not have the right to appeal. So if they lost, over, done. Defendants do have the right of appeal. Why is that? It's because they didn't have a lawyer in their case, and in order to allow them to be represented, they can be when they have lost and they're appealing, because the trials are held what they call de novo, meaning from the beginning. I have a whole chapter, probably about 40 pages, on small claims court, the procedures, how do you go there, what does it cost you, if anything, how the case heard, appeals, evidence, and all the rest. You can really learn a lot about small claims, pretty much everything you need to know, because I poured into it pretty much everything that I did for all the years that I was on the bench dealing with small claims court cases. Best way, most inexpensive, and you're done quick. Small claims court. Talk to you about that later on. Go to the book, From the Trench to the Bench, Navigating the Legal System and Finding a Spiritual Path Along the Way, and you'll find out all you need to know.